In 1964, Title VII was passed prohibiting employment discrimination based on race, religion, color, and national origin. Since then, many cases have revolved around it. The first sex discrimination case around Title VII was Phillips versus Martin Marietta Corporation in 1971. The court unanimously ruled that the employers could not refuse to hire women with preschool-age children while hiring men with children of the same age. 6 years later, in 1977, Bach brought forward issues surrounding affirmative action by stating that he was discriminated from medical school because he was not a minority. He felt that this was just another form of discrimination. The Supreme Court ruled against the school and orders it to admit him.
Definition check. Affirmative action is the encouragement of increased representation of women and minority group members, especially in employment.
But how does this affect us today? Didn't we solve all of these problems in the past?
Have you or a loved one ever felt discriminated against in the workplace or felt unfairly treated? Call us today at 1-800-LAWYERS. We solve all types of discrimination problems with limited or no interruptions to your work. We almost got Walmart? We can deal with your boss. Call us today, 1-800-LAWYERS.
In 2000, Betty Dukes, a 54-year-old Walmart worker in California, claimed sex discrimination. Despite 6 years of work and positive performance reviews, she was denied the training she needed to advance to a higher salaried position. Walmart argued Dukes clashed with a female Walmart supervisor and was disciplined for admittedly returning late from lunch breaks. In June 2001, the lawsuit began in U.S. District Court in San Francisco. The plaintiffs sought to represent 1.6 million women, including women who were currently working or had previously worked in a Walmart store since December 26, 1998.
I brought this case because I believe that there was a pattern of discrimination at Walmart, not just in my store, but I believe it is across the country. Since we have filed our lawsuit since 2001, I have heard from numerous women telling me basically the same story is mine of disparate treatment and lack of promotion as well and lack of pay.
In 2004, the federal district judge, Martin Jenkins, ruled in favor of class certification under FRCP 23B2. That a class action may be maintained if Rule 23A is satisfied and if the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. The court appealed the decision.
Definition check. A class action lawsuit is a lawsuit brought by a representative member of a large group of people on behalf of all members of the group.
2007, a 3-judge panel of the Ninth Circuit affirmed the district court's class certification. Walmart promptly filed for a rehearing and a rehearing en banc, contending that the majority committed legal error with regard to whether the grounds for class action certification had been met. On December 11, 2007, the same Ninth Circuit panel withdrew its initial opinion and issued a subsequent and superseding opinion that still permitted the class certification. The panel dismissed the original petition for a rehearing as moot in light of its superseding opinion on the grounds that the revised opinion addresses the legal errors claimed in the petition, although Walmart was permitted to refile its petition. Walmart again filed for a rehearing en banc.
Definition check. En banc is a legal term used to refer to a case heard or to be heard before all judges of court rather than a panel selected by them.
On February 13, 2009, the Ninth Circuit granted Walmart's petition for a rehearing en banc on the class action certification. This meant that the December 2007 Ninth Circuit opinion was no longer effective. On March 24, 2009, a panel of 11 Ninth Circuit judges, led by Chief Judge Alex Kozinski, heard oral arguments for the en banc appeal. On April 26, 2010, the en banc court affirmed the district court's class certification on a 6-5 vote. Walmart's lead appellate counsel, Theodore Betrus Jr., said in a statement that the decision violates both due process and federal class action rules, contradicting numerous decisions of other federal appellate courts and the Supreme Court itself, and indicated that Walmart would appeal to the U.S. Supreme Court. On December 6, 2009, the Supreme Court agreed to hear Walmart's appeal as Walmart v. Dukes. The oral argument for the case occurred on March 29, 2011.
To allow reconstruction of the decisions. That is not a process known to our jurisprudence. It doesn't comport with due process. It takes away Walmart's rights under Title VII. It injures the rights of the individual women whose the record...
Well, you don't seriously contend that if a plaintiff, if a policy were found or practice of discrimination, that a woman couldn't come in and say, they put X in, I had a longer history at Walmart, I had far superior job ratings, I had no criticisms of my work, and I wasn't promoted. Wouldn't that be enough for her to show that that policy influenced her lack of selection?
I agree with you, Justice Sotomayor.
And your personal database has all that information, so why is it impossible to try these cases other than because of their large number? That's a different issue.
Yes, Your Honor. What you just outlined, we agree that a woman should be able to come in and say that. She may say, well, the records don't show what really happened. I had more experience. I was a much better employee than the guy working next to me.
On June 20, 2011, the Supreme Court ruled in Walmart's favor, saying the plaintiffs did not have enough in common to constitute a class. The court ruled unanimously that because of the variability of plaintiffs' circumstances, the class action could not proceed as comprised, and 5-4 that it could not proceed as any kind of class action suit. There were many consequences of this case. In 2 years, it has been cited more than 1,200 times in rulings by federal and state courts. The size of employee settlements also decreased. In 2010, the year before the Dukes decision, the top 10 settlements totaled $346 million. In 2012, the first year after Dukes, the total plummeted 87% to $45 million. Also, less employment discrimination class action lawsuits are being filed. Before Dukes, it was normal to see 25 or 30 such cases every year. Now, the number of new cases is closer to 10 or 12 a year. Other effects are extremely far-reaching. In particular, the court rejected a 35-year-old framework for calculating monetary damages in employment discrimination class actions. Instead of using a statistical formula that assessed damages for the whole class, plaintiffs now had to have individual trials. In addition, some of the language when allowing a class action lawsuit to proceed changed. For instance, the decision said that for a class action lawsuit to proceed, plaintiffs would now have to show significant proof of a general policy of discrimination on the part of the employer. The ruling used some new language, and no one was quite sure what it meant or how to approach it. But for advocates for women and minority workers, the mood is mostly dispirited. Economic disparities between people of color and whites and between men and women have been widening, and complaints of mistreatment in the workplace are common. Everyone is working hard to see that people get treated fairly.
The Walmart class action suit reveals that discrimination still affects us in the workplace today. Thanks for watching.